it was struck out, and the parties proceeded to adopt. The defendants adopted, and the claimant's final address was deemed adopted pursuant to the rules of court.
But my lord, we were not that date. We were not aware of that date. I just want to be on record.
You were not aware. I will record you that you were not aware. But hearing notice was served. Hearing notice was served to all the parties. Please, I will record you. Yes. Kabe Akingbolu, you say you were not.
Yes, my lord. Okay. Yes, my lord. We were not aware of that date.
Hello?
Yes, I am writing.
Idigbe, please. We were not aware of that date, so that was why we were not in court.
The Bluetooth device is ready to pair. The Bluetooth device is connected successfully.
Yes, I don't know, Mr. Ogungwemi, do you have anything to say in respect of the observation?
Well, we were offline for a while, so I don't really know. But what he stated was that the one I had was that there was a application which I know was struck out before the adoption on the last date.
Okay. All right. I will just, I have heard Mr. Akingbolu. Hearing notice was served on all counsel, as can be seen from the records of the courts. At the sitting of the 19th of July, 2021, the claimant's application for leave to amend his processes was struck out. The claimant's final address, which was before the court, was deemed adopted pursuant to the rules of court. I will proceed to read the judgment.
As the court, please.
In reading the judgment, I shall simply read the claims and I shall proceed straight to the decision section.
As the court, please.
The claimant filed this complaint against the defendant on the 27th of September 2013, together with the accompanying processes. By an amended statement of claim filed on 12th June 2018, he is seeking the following reliefs. A declaration that the refusal of the defendant to pay the claimant's pension from January 2011 till date is in breach or violation of the claimant's contract of employment, as stated in the claimant's termination letter dated 12th October 2009. B, a declaration that the claimant is entitled only to his full benefit under the old Pension Act, which was the law in force when he was employed in 1980. C, a declaration that Section 8 and 12 of the Pension Reform Act 2004 is unconstitutional for being retroactive in application or effect in relation to the right of the claimant and therefore void. An order directing the defendants to pay to the claimant the sum of 19,666,389 naira 40 kobo, being the pension arrears for 7 years, broken down as follows. Total amounting to 1,638,865 naira 62 kobo. E, an order for interest on the arrears for pension on 13th month pay at 20% till the final liquidation of the total judgment sum. F, an order of court compelling the defendants to continue to pay claimant his pension in accordance with his terms of contract. G, an order of court compelling the defendants to pay the claimant the sum of 2 million naira as general damages for the embarrassment, physical and psychological trauma suffered by the claimant. H, interest on the arrears of pension at 20% till the final liquidation of the total sum. I, cost of the action in the sum of 1 million naira. J, in the alternative to C, an order mandating the defendants to transfer the sum of 70,237,005 naira less 3,742,978 naira 93 kobo already paid by the defendant for 16 months before the suit arose. L, interest on the arrears of pension at 20% till the final liquidation of the total sum. The defendant filed a second amended statement of defense on 8 November 2018, together with the accompanying processes. I will go straight to the section. I have carefully considered all the processes filed, the evidence led, the written submissions, arguments, and authorities canvassed by counsel in the final addresses in this matter. The claimant, as required, has put in evidence the defendant's letter terminating his employment, Exhibit C1, letter of terminal benefits, Exhibit C2, letter of appeal, Exhibit C5, letter of demand, Exhibit C7, and other service documents. It is the law that a claim is circumscribed by the reliefs claimed. The duty of the claimant, therefore, is to plead only such facts and materials as are necessary to sustain the reliefs and adduce evidence to prove same. He may, at the end of the day, obtain all the reliefs claimed or less. He never gets more. Nor does he obtain reliefs not claimed. A court is therefore bound to grant only the reliefs claimed and cannot grant reliefs not claimed. See Gabriel Atibe versus Cable Metal, Nigeria Limited. It is also the law that once a party asserts, he must prove the assertion. Section 1311 and 2 of the Evidence Act. The issues that arise for determination are as follows. 1, was the defendant right to have paid the claimant pension under its pre-existing pension scheme after the commencement of the Pension Reform Act? 2, Are the provisions of sections 8 and 12 of the Pension Reform Act 2004 unconstitutional and retroactive? 3, whether on the pleadings and evidence the claimant has been denied his pension rights. There is no dispute that the claimant's appointment was terminated with effect from 12th October 2009. The defendant, on the 20th of November 2009, wrote to the claimant advising him of his terminal benefits, specifically his gratuity and pension. The letter is reproduced as follows. We advise that the gratuity of 12,328,184 naira 40 kobo has been approved for you, sequel to the termination of your appointment, with effect from 12th October 2009. The amount represents 294% of your terminal annual emolument, calculated in accordance with the current gratuity rate. Your account will be credited with the sum of 12,328,184.40, being the total amount due to you to the debit of profit and loss account. In keeping with the terms of the current pension and gratuity scheme, you are entitled to an immediate pension of 2,809,484 naira 20 kobo per annum, calculated on the basic of 67% of your total terminal emoluments, terminal basic salary, housing, transport, and lunch, having attained the age of 45 years. The gratuity is not subject to tax deduction, but the authority of State Board of Inland Internal Revenue must be obtained as per the personal income tax guidelines. Any unearned payments, benefits, e.g. housing, furniture allowance made in advance should be deducted from entitlement before disbursement of fund. All outstanding loans should be deducted immediately. Your emoluments are as shown below. Terminal basic salary, 1,798.260. Housing allowance, 1,410,000. Transport allowance, 705,000. Lunch allowance, 280,000. In line with the provision in the pension scheme, you are required to confirm your existence biannually to the Chief Marketing Officer for the continual payment of the pension. I find from this letter, and there is no doubt in my mind, that the pension and gratuity referred to is the defendant's in-house scheme existing before the commencement of the Pension Reform Act 2004. The Pension Reform Act came into effect on the 25th of June 2004. The claimant's appointment was terminated on 12th October 2009, about 5 years after the commencement of the Pension Reform Act 2004. Therefore, the pension law applicable when the claimant was disengaged is the Pension Reform Act 2004, and I so hold. Consequently, from the 25th of June 2004, it was wrong for the defendant to continue its pension administration in contravention of the Pension Reform Act 2004. The evidence of DW is that the letter, Exhibit C2, was written in error, and the claimant ought not to have been paid in accordance with its pre-existing in-house scheme, as the defendant is not a closed pension fund administrator or a pension fund custodian, as provided by sections 39 and 40 of the Pension Reform Act 2004 for the management of private sector pension schemes. This evidence is unchallenged by the claimant. Sections 8.1 and 12.1b of the Pension Reform Act provides as follows. 8.1. Notwithstanding the provisions of subsection 2 of section 1 of this act, any employee who at the commencement of this act is entitled to retirement benefits under any pension scheme existing before the commencement of this act but has 3 or less years to retire shall be exempted from the scheme. 12(1)(b). As from the commencement of this act, the right to retirement benefits of any employee who is already under any pension existing before the commencement of this act and has over 3 years to retire shall, in the case of the employees of the public service of the Federation, Federal Capital Territory, and in private sector, credit the retirement savings accounts of the employees with any funds to which each employee is entitled. And in the event of an insufficiency of funds to meet this liability, the shortfall shall immediately become a debt of the relevant employer and be treated with the same priority as salaries owed. Where there is such a debt, the employer shall immediately issue a written acknowledgement of the debt to the relevant employee and take steps to meet the shortfall. The claimant, who was still in service until the defendant disengaged him on 12th October 2009, did not qualify as an employee with less than 3 years to retire from the commencement of the Pension Reform Act 2004, so as to enjoy the exemption in Section 8 of the Act. The claimant still had more than 3 years to retire from service. Therefore, the provision of Section 12(1)(b) of the Pension Reform Act 2004 is applicable to the claimant. The claimant's retirement savings account that he is mandatorily required to maintain pursuant to Section 11 of the Act is to be credited with the funds he is entitled to under the pre-existing scheme. The evidence shows that the defendant has a sum of 3,731,781 naira 77 kobo, representing the claimant's accrued pension rights as at December 31, 2005, scheme to his retirement savings account at Idigbe Pension PFA Limited, in line with the law and the directives of the National Pension Commission. The claimant confirmed in cross-examination that the defendant transferred the pension to his PFA. I therefore find that the defendant has complied with the provision of Section 12(1)(b) of the Pension Reform Act 2004. The claimant is therefore not entitled to the declaratory relief number B. The claimant is seeking a declaration that the defendant will pay him pension from January 2011 till date, which of his contract of stated in the termination letter dated 12 October 2009. There is no such statement in the letter of termination. Furthermore, there are no pleadings in respect of the contract of employment. Neither has the claimant placed his contract of employment before the courts. The law is set that parties are bound by their pleadings, Luchem versus Gucci. And as his lordship Sir JSC puts it in Chief James Onyewuke versus Modu Sule on the issue of pleadings, a trial judge did not embark on a voyage seeking to repair the damage caused by counsel in failing to plead material facts necessary to obtain judgment in the temple, since courts are not carpenters' workshops where judges toil to mend defects in pleadings. The claimant's own evidence in cross-examination is as follows, and I quote, "Yes, I have been receiving my monthly pension, but that is not what I'm supposed to get. I started receiving my pension in 2017 or 2018, I cannot remember. Yes, I have been receiving pension since 2016, and since I exited the bank in 2009 before they stopped it." Exhibit D2 is the claimant's retirement savings account statement for the period 1st February 2009 to 10th of August 2015. It shows that on 27 June 2011, the claimant received a lump sum payment of 231,363 naira 75 kobo and arrears of 137,378. He also received his monthly pension for the entire period. I find from the totality of the evidence that the claimant has received his monthly pension from January 2011 till date. Consequently, the main head of claim A and claims D 1 to 7, claim F and H must fail. They are hereby refused. The claimant is seeking a declaration that sections 8 and 12 of the Pension Reform Act are unconstitutional for being retroactive in application or effect in relation to his pension rights and therefore void. Retroactive means taking effect from a date in the past. The claimant has not shown how these provisions are unconstitutional and retroactive. Under the provisions of section 36(8), subsection 8 of the 1999 Constitution as amended, the rule against retrospective or retroactive legislation applies to penalties and criminal law only. Consequently, the declaration sought in the head of claim C must fail together with the alternate reliefs K and L. Claimant has made a claim for 13th month pay for the period 2011 to 2017 and has pleaded that he is entitled to it as of right as an ex-employee. The uncontroverted evidence of DW is that the 13th month salary to ex-staff of the defendant is paid to members of the Union Bank Pensioners Association only. The Sorry, our connection went off. Yes, I will continue from where I stopped. The claimant is seeking a declaration. I hope all counsel can hear me, please. Yes. The claimant is seeking a declaration that sections 8 and 12 of the Pension Reform Act are unconstitutional for being retroactive in application or effect in relation to his pension rights and therefore void. Retroactive means taking effect from a date in the past. The claimant has not shown how these provisions are unconstitutional and retroactive. Under the provisions of section 36(8) of the Constitution, as amended, the rule against retrospective or retroactive legislation applies to penalties and criminal law only. Consequently, the declaration sought in the head of claim C must fail together with the alternate reliefs K and L. Claimant has made a claim for 13th month pay for the period 2011 to 2017 and has pleaded that he is entitled to it as of right as an ex-employee. The uncontroverted evidence of DW is that the 13th month salary to ex-staff of the defendant is paid to members of the Union Bank Pensioners Association only. The claimant averred in his pleadings that he's not a member of the Union Bank Pensioners Association and that any resolution with the defendant has with the association is not binding on him. As I had earlier stated above, the law is that parties are bound by their pleadings. The judgment the claimant has relied on as his justification for 13th month salary for him was delivered on September 30, 2014 in suit number NICN/LA/555/2012 between the registered trustees of Union Bank Pensioners Association versus Union Bank of Nigeria. Having stated that he is not a member of the association, the claimant cannot claim any benefits arising therefrom, and he has failed to place before the court the document that entitles him as of right to 13th month salary after his exit from the defendant. Exhibit RAA2 is the claimant's statement of account. It reveals that the claimant paid dues, a special levy of 8,542 naira 21 kobo to the Pensioners Association. Now, if the claimant was not a member of the association, why did he pay the levy? I also find from Exhibit RAA2 that the defendant paid the claimant 13-month salary in 2015, 2016, 2017, and 2018. And all of these payments were in line with the post-judgment settlement agreement that brought the terminal date for 13th month salary to 2018. How then can the claimant make claims for 13th month salary that he had already received? It is my considered view that the claimant, having benefited from membership of the association, now seeks to deny his membership so as not to be bound by the post-judgment settlement. From the evidence, the claimant is a member of the association and is bound by the decisions of the association. He is not entitled to be paid 13-month salary, not being an employee of the defendant. I find the claimant not to be a witness of truth. These claims, D 8 to 15 and F, are refused. The claimant has made a claim for general damages and costs of the action. There is no evidence of the wrong done to him by the defendant that entitles him to damages. Neither is there evidence of the embarrassment, physical and psychological trauma he has suffered. This claim fails together with the claim for costs. On the whole, the claimant has failed to prove his case. It is hereby dismissed in its entirety. Cost of 50,000 naira awarded the defendant. Judgment is entered accordingly.
As the court pleases. We appreciate your lordship.
Please call the next case.
NICN LA 311-2015. And First Bank of Nigeria.
Parties, are the parties present, please? Any of the parties?
IP Akubwe.
Appearance, please.
IP Akubwe, appearing for the plaintiff, my lord.
IP
Akubwe, Akubue.
For the claimants, any appearance for the defendant, please?
Yes, my lord. My name is Uche Udoji. I'm appearing for the defendant.
As I had said earlier, I shall simply read the claims and go to the decision section.
As the court pleases.
Court pleases.
Everything is included in the judgment, but you know we are virtual, so we have to take into consideration interruptions as well.
As the court pleases.
Judgment. The claimant filed this complaint against the defendant on the 25th of June, 2015, together with the accompanying processes. By an amended complaint and statement of facts filed on the 19th of April 2018, the claimant is seeking the following reliefs. 1, a declaration that the defendant's summary dismissal of the claimant was malafide and wrongful. 2, an order of this honorable court directing the defendant to convert the claimant's dismissal to termination, or in the alternative, give the claimant the option to tender her resignation. 3, an order of this honorable court directing the defendant to pay the claimant the following entitlements immediately. A, pay for performance for 2013, 925,454 naira 14 kobo. B, outstanding gratuity as at June 2014, 562,972 naira 8 kobo. C, leave allowance for the year 2014, 428,543 naira 97 kobo. D, basic salary in lieu of the required 1 month notice period, 191,047 naira 43 kobo. 6, cost of action in the sum of 1 million naira only. 4, cost of action in the sum of 1 million naira only. 5, general damages in the sum of 10 million naira only for the hardship and defamation of character suffering by the claimant as a result of the unjust and wrongful summary dismissal by the defendant. The defendant filed a statement of defense and a counterclaim on 30th October 2015, together with the accompanying processes. The defendant counterclaimed as follows. A, the sum of 3,101,291 kobo only, being the debit balance on the account as at 19th of October 2015. B, interest as the court may determine till judgment and thereafter till full liquidation of the sum. C, cost of this defense and counterclaim. The claimant filed a reply to the defendant, to the defense on the 18th of November 2015. I go to the decision. I have carefully considered all the processes filed, the evidence led, the written submissions, arguments, and authorities canvassed by counsel in the final addresses in this matter. The claimant has put in evidence her letter of employment, Exhibit C1, confirmation of appointment, C2, employee handbook, C9, letter of dismissal, C5, letters of appeal, C6 and C7, and other service documents. Also placed before the court by the defendants, counterclaimants, are the queries issued the claimant and her responses, Exhibit D2, D4, D6. Alert notification of excessive access to dormant accounts, Exhibit D5. Application for loan, D7. Offer of credit facility, D8. Personal loan agreement, D9. The law is settled that when an employee's employment is terminated and the reason is given, A duty is imposed on the employer by law to establish the reason to the satisfaction of the courts. See Olatunbosun versus Nicer Council. The issues for determination are therefore as follows. 1, whether the defendant has established the reason for which it summarily dismissed the claimant. 2, whether on the pleadings and evidence the claimant is entitled to the reliefs she is seeking. 3, whether the defendant has proved the counterclaim. The defendant, in its letter dismissing the claimant, dated August 18, 2014, did not give a reason for her summary dismissal. The defendant simply states, "This letter serves to advise that you are summarily dismissed from this organization with immediate effect. Please take note and be informed accordingly." However, the defendant, in joining issues with the claimant in its pleadings, has given and explained the reasons for the claimant's summary dismissal, which are unauthorized debits of 170,000 in the dormant account of a deceased customer, Mrs. Abigail Adeyemi, unauthorized reactivation and debit of 86,000 naira on another dormant account belonging to Eden Dorothy Achibong, unauthorized logging in and accessing information on dormant accounts, violating the defendant's policy on unsolicited viewing of FBN customer accounts on Finaco. Having given these reasons, the onus is on the defendant to establish that the claimant was indeed culpable of this misconduct to the satisfaction of the court. The law is that he who asserts must prove. Section 1311 and 2 of the Evidence Act, Calabar Cooperative Limited versus ECPO. See also Elegushi versus Oseni. The defendant's investigation revealed that the claimant reactivated the dormant accounts without authorization, and her staff serial number was captured in the reactivation and payment to unknown persons. The defendant's interlink system that keeps records of files accessed by its staff revealed that the claimant regularly viewed dormant accounts of customers without authority. The claimant was queried several times, both orally and in writing, and she admitted this. I find her responses to the queries are inconsistent. In cross-examination, she admitted paying the sum of 170,000 naira from the account of late Mrs. Abigail Adeyemi and the sum of 86,000 posted by her in respect of the account of Eden Dorothy Achibong. The claimant has complained that the disciplinary procedure denied her a hearing. By the claimant's own evidence, she was queried and appeared before the disciplinary committee, where she was questioned and she answered the questions. Facts admitted require no further proof. Sunday Adegbite versus Adegboro. I find that the procedure that ultimately culminated in the claimant's appearance before the disciplinary committee is in accordance with her employment contract. Fair hearing simply means hear the other side. The Supreme Court in the case of Imonike versus Unity Bank has held that where an employer accuses an employee of misconduct by way of a query, and the employee answers the query before the employer takes a decision on the employee's appointment, that satisfies the requirement of fair hearing. I hold that the claimant was given a fair hearing. From the totality of the evidence, the defendant has established to the satisfaction of the court the reason it summarily dismissed the claimant. The defendant's employee handbook, paragraph 14.5, deals with summary dismissal and states that an employee may be summarily dismissed for certain acts of gross misconduct or negligence. This includes dishonest / fraudulent practices and any other acts of gross misconduct. There can be no doubt the claimant's misconduct falls into these categories. The claimant's misconduct is grave and weighty. It has eroded and undermined the confidence reposed in her by the defendant to carry out her duty. I hold that her dismissal is in accordance with her contract of employment, and it is lawful. C. Lawrence Azenobo versus Bayero University, Kano, Borishade versus NBA, and Ajayi versus Texaco. Claimant has made claims for salary in lieu of notice, performance pay, leave allowance, and gratuity. The defendant's employee handbook, paragraph 14.5 states, and I quote, "No notice shall be given in the case of summary dismissal. In the event of summary dismissal, all terminal benefits shall be forfeited to the bank. In the event that the terminal benefit paid cannot take care of his outstanding liability to the bank shall be free to proceed against him to recover the outstanding balance," end of quote. Consequently, the claimant is not entitled to salary in lieu of notice or gratuity, having forfeited same to the defendant bank following her dismissal. There is no evidence of entitlement to leave allowance or performance pay before the court. Indeed, the claimant testified that she did not receive performance pay due to her disciplinary issues. On the claim for damages, the claimant has not established the hardship or wrong done to her by the defendants, and the pleadings do not contain the words published concerning her to sustain a claim for defamation. The claim for damages and for costs fails. On the whole, the claimant has failed to prove her case. It is dismissed in its entirety. Cost of 100,000 naira awarded the defendant on the main claim. On the counterclaim, the claimant admitted in cross-examination that she applied for a loan of 3.5 million and she has not fully paid up, and she had not fully paid up before she was dismissed. The defendant informed the claimant by Exhibit D10, dated September 18, 2015, that her net indebtedness was 2,296,666 naira 93 kobo, and that she had 30 days to pay up, failing which it would attract commercial interest rate. The defendant has put the sum outstanding as 3,101,291 naira. The claimant did not refute this figure. I therefore find the counterclaim to be admitted by the claimant / defendant to counterclaim. Facts admitted require no further proof. Sunday Adegbite versus Adegboro and others. The defendant has proved the counterclaim. The claimant is ordered to pay the sum of 3,101,291 naira to the defendant within 30 days. Thereafter, the sum will attract interest at the rate of 10% per annum until it is fully liquidated. Cost of 100,000 naira awarded the defendant on the counterclaim. Judgment is entered accordingly.
We are most grateful for the erudite ruling judgment of the Honorable Court.
We are grateful, my lord.
Registry. Please call the next case.
NICN LA 758/2016. The case of Dr. Idigbe and Covenant University.
Are the parties present? Appearance.
May it please my noble Lord, Femi Akinyemi is my name.
Femi
Akinyemi.
Akinyomi.
Akinyemi.
Akinyemi.
Yes, my Lord.
Yes.
My appearance is for the claimants, my Lord.
Any appearance for the defendant? Any appearance for the defendant, please?
Yes, my Lord.
Yes.
Yeah, my name is FB Agbang. FB Agbang. Agbang is spelled AGBANW. I appear for the defendant.
Like I said earlier, I shall simply read the claims and then I go straight to the decision section of the judgment. Judgment. The claimant filed this complaint against the defendant on 8 December 2016, together with the accompanying processes, seeking the following reliefs. 1, a declaration that the defendant's letter dated November 14 and 15, 2016, purportedly terminating the claimant's employment with the defendant without affording the claimant the opportunity to be heard is wrongful, null and void, and of no effect, as it violates the provision of sections 36 of the 1999 Constitution of the Federal Republic of Nigeria as amended, the Covenant University Staff Handbook and Conditions of Service, and the Covenant University Law. 2, an order directing the defendants to withdraw their aforesaid letter dated November 14 and 15, 2016, purportedly terminating the claimant's employment with the defendant and restore the claimant to his position as a director of Covenant University Counseling Center in the defendant. 3, an order mandating the defendant to pay the claimant the arrears of salaries and emoluments due and accruing to him from November 14 and 15, 2006 till date. 4, an order directing the defendant to reimburse the claimant for the cost of traveling flights and shipment of personal effects for the purpose of resuming duties upon appointment by the defendant. 5, an order of perpetual injunction restraining the defendant, whether by themselves, their agents, servants, privies, or assigns, howsoever defined, from acting or implementing the contents of the aforesaid defendant's letter, dated November 14 and 15, 2016, purportedly terminating the claimant's employment with the defendant in any manner whatsoever and howsoever, or interfering in the claimant's duties as a director of Covenant University Counseling Center in the defendant. 6, the cost of action assessed at 2 million naira. The defendant filed the statement of defense together with the accompanying processes on the 25th of January 2017. I go straight to the decision section portion. I have carefully considered all the processes filed, the oral and the documentary evidence in support, the authorities and submissions canvassed by counsel. The law is settled that when an employee complains that his employment has been unlawfully terminated, he has the burden not only to place before the court the terms and conditions of his employment, but the manner in which the employer breached the terms and conditions. See Okoibo versus Police Council. Also see Doni Boye Obu versus NNPC. In furtherance of this, the claimant has placed before the court his letter of appointment, Exhibit C2, the defendant's staff handbook and conditions of service C3, the Covenant University Law C4, letters of termination of appointment C10 and C12, and other service documents. The law is settled that whosoever desires the court to give judgment as to any legal right or liability dependent on the existence of facts which he asserts must prove those facts exist. Section 131, 1 and 2 of the Evidence Act. Calabar Cooperative versus ECO. It is also the law that civil suits are decided on the balance of probabilities and on the preponderance of evidence. There is no dispute between the parties in the pleadings on the following facts. The defendant is a higher institution of learning set up by the World Mission Agency, WMA, an offshoot of the Living Faith Church worldwide. The defendant employed the claimant as a full-time director of his counseling center from Vancouver, Canada, with effect from October 1, 2007. He was to discharge his duties in accordance with the defendant's staff handbook and conditions of service. I find that a religious organization set up the defendant and that it is a private university. The defendant disagrees with the claimant's position that he discharged his duties in accordance with the Covenant University Law 2001. The issues that therefore arise for determination are as follows. 1, whether the claimant's employment by a private university is one with statutory flavor. 2, whether the defendant wrongfully terminated the claimant's employment. 3, whether on the pleadings and evidence the claimant is entitled to be reimbursed for his baggage and traveling expenses. Learned counsel to the claimant has submitted in final address that the claimant's employment is one with statutory flavor, making reference to Covenant University Law 2001. There are no pleadings by the claimant as to how this makes his employment one with statutory flavor. And as such, the defendant has not joined issues on its statutory status in the pleadings. The law is settled that parties are bound by their pleadings, Iwoluchem versus Gucci, and arguments of counsel in written address cannot be a substitute for pleadings or evidence. Okwejimino versus Bakeji. An employment is said to have statutory flavor if it is created and governed by statutes or regulations derived from statutes. Ishitabe versus the Federal Public Service Commission, National Electric Power Authority versus Ango, Idoniboyi versus Obu. The Covenant University Law 2001 did not create the position Director, Counseling Center. The claimant's letter of appointment, Exhibit C2, did not state that his employment was to be regulated by Covenant University Law 2001. At this juncture, it is pertinent to state that case law on appointments with statutory flavor are in relation to public service appointments in the federal, state, and local government levels, and not private sector appointments. Section 318 of the 1999 Constitution as amended states that, and I quote, public service of a state means the service of the state in any capacity in respect of the government of the state, and includes F, staff of any educational institution established or financed principally by a government of a state. The defendant is not established or financed by the Ogun State government. It is a private university established by World Mission Agency, an offshoot of the Living Faith Church worldwide. Therefore, upon being licensed to operate as a private university by the National University Commission, the Ogun State government has granted the defendant a charter by which it has been established and its rights and privileges defined in the document Covenant University Law 2001. I find that the claimant is not in the service of Ogun State I hold that the claimant's appointment is not one with statutory flavor. Consequently, the claimant cannot be reinstated to the position of director, Covenant University Counseling Center, paid arrears of salary, or granted an injunctive order. The claimant's reliefs, number 2, 3, and 5 must fail. They are hereby refused. The claimant has complained that the termination of his employment was malicious and illegal, and that he was not given the opportunity to be heard. The law, the domestic law, international labor standards, and international best practices impose on the defendant a duty to establish the reason for the termination of the claimant's employment to the satisfaction of the court. See Olatunbosun versus NISA Council. The Covenant University Law 2001 in section 28 empowers the council to remove academic staff or administrative staff for good cause. And section 29 defines good cause to include A, conviction for any offense which the council considers to be such as to render the person concerned unfit for the discharge of the functions of his office. B, any physical or mental incapacity which the council, after obtaining medical advice, considers to be such as to render the person concerned unfit to continue to hold office. C, conduct of a scandalous or other disgraceful nature or acts contrary to the ideas of the university, which the council considers to be such as to render the person concerned unfit to continue to hold his office. D, conduct which the council considers to be such as to constitute failure or inability of the person concerned to discharge the functions of his office or to comply with the terms or conditions of his service. The management of the defendant that appointed the claimant also terminated his appointment, and not the University Council. The question that arises is whether the claimant was removed for justifiable reason connected with the performance of his work and or for good cause. The defendant issued the claimant 2 letters of termination dated 14th November 2016 and 15th November 2016. The undisputed evidence adduced is that the defendant on the 25th of October 2016 wrote to the claimant informing him that, and I quote, his tenure of appointment as director, Covenant University Counseling Center, has come to an end of quote, and that the management has approved, I quote, your change of department from Covenant University Counseling Center to Department of Psychology as senior lecturer contract, end of quote. The claimant was advised to hand over and proceed to the acting head of Department Psychology for proper academic engagement. The claimant responded by writing Exhibit C9 on October 28, 2016 to the Chancellor and Chairman of Board of Regents, stating that his employment as director is permanent and not tenured, a full-time position, and is a career clinical professional position. He stated that the offer of a contract, senior lecturer appointment, was unsolicited by him, as he never expressed to anyone a desire for full-time career change, stating, and I quote, I could consider occasional teaching, 1 or 2 courses on a voluntary, auxiliary, or part-time basis, concurrently with my primary clinical duties as director, Covenant University Counseling Center, as I have done for years without pay in Covenant University, end of quote. The defendant again wrote the claimant on 7th November 2016, informing him that his appointment tenure has been reviewed to a contract appointment and that he is entitled to, I quote, terminal benefits of your regular appointment within the stipulated period of 8 years, 9 months, and 29 days, end of quote, and that the total amount payable to him is 1,750,137 naira 42 kobo. The registrar of the defendant on November 10, 2016, wrote to the claimant to hand over immediately. There is no evidence that the claimant consented to a change to his position, nor is there evidence of the retirement age for staff of the claimant's cadre, or that the claimant was due to retire. There is no doubt that by the actions of the defendant and its registrar's letter, the defendant had constructively dismissed the claimant. This is clear from the fact that the defendant knew the claimant would not find the position of senior lecturer professionally fulfilling, as he had in his letter Exhibit C9 stated unequivocally that the clinical practice of psychology as a psychotherapist and a counselor was the path professionally fulfilling for him. Therefore, it is my considered view that the defendant's unilateral review of the claimant's employment contract to that of senior lecturer contract that was unsolicited was designed to be intolerable to him and to force his exit. This is what is known as a constructive dismissal. The claimant responded to the registrar's letter on November 14, 2016, stating the reasons the handover had not happened. That included awaiting a response to his appeal to the Chancellor and the Chairman Board of Regents. The defendant responded by terminating the claimant's employment by its letter also dated November 14, 2006. The relevant portion of the letter states as follows, and I quote, "Sequel to the ongoing organization review of the Covenant University, it has become pertinent to restructure our personnel base. Management has resolved that your services as senior lecturer contract will no longer be required. Therefore, your appointment is hereby terminated with immediate effect." End of quote. Upon the receipt of the letter, the claimant sent a memo to the defendant's registrar stating that, I quote, "The senior lecturer contract with my name inserted in the Department of Psychology, purportedly terminated, was not my position for which I was employed by the Covenant University, and that I accepted the employment for almost 9 years now." In response to the claimant's memo, the defendant issued a second letter of termination, stating as follows, "This is to inform you that the management of Covenant University no longer requires your service as director, Covenant University Counseling Center. Therefore, your appointment is hereby terminated with immediate effect." The reasons given by the defendant in the two letters of termination, restructuring and services no longer required, are not within the definition of good cause in section 29 of the Covenant University law. There is no evidence of restructuring before the court, and the reason of services no longer required is not a valid reason because it has not been justified. The termination of the claimant's employment with immediate effect suggests wrongdoing that the defendant must justify. There is no evidence of wrongdoing before the court. There is also no evidence that a disciplinary process commenced against the claimant. Consequently, the issue of fair hearing does not arise. Furthermore, the claimant not receiving a response to his appeal to the Chancellor and Chairman Board of Regents is not an issue of a breach of his right to a fair hearing, and I so hold. This court has been empowered in section 254C(1), F and H of the 1999 Constitution as amended to apply international best practices in labor disputes. The Court of Appeal, in its decision in Sahara Energy Resources Limited versus Oyebola, delivered on 3rd December 2020, unequivocally stated that this court has a duty to apply international best practices in its decisions and quantum of damages. It is contrary to international best practices for an employer to terminate the employment of its employee without any reason or justifiable reason that is connected with the performance of the employee's work. See Pengasan versus Slumberger and Adriel, where this court recognized that it is not globally acceptable in industrial relations and practice to terminate the employee's employment without adducing any reason for doing so. In Aloysius versus Diamond Bank, PLC, the court relying on Article 4 ILO Termination of Employment Convention, 1982, and recommendation number 166 held that it is contrary to international labor standards and international best practices for an employer to terminate the employment of its employee without any reason or justifiable reason that is connected with the performance of the employee's work. See also Uzo Ejekumadu versus Blue Arrow TSW Limited. I find that there is no reason established before the courts by the defendants to justify a constructive dismissal that was followed by the issuance of 2 letters of termination with immediate effect. The defendant has failed to establish the wrongdoing that necessitated the claimant's termination of appointment with immediate effect after 8 years, 9 months, and 29 days of service. The words with immediate effect have the effect of stigmatization. I hold that the termination of the claimant's employment is wrongful. I find that the defendant did not pay the claimant his 1 month's salary in lieu of notice upon the sudden termination of his employment on the 14th and the 15th of November 2016. Rather, it lumped his salary in lieu of notice with other entitlements and exit procedures. The law requires the defendant, having terminated the claimant's employment without giving notice as provided in his employment contract, must pay him at the time of termination salary in lieu of notice and promptly inform him. The defendant ought to have paid the claimant's salary in lieu of notice directly to him or to his bank account on the 14th or 15th of November 2016, and the claimant promptly informed of the payment. Payment made thereafter is not in fulfillment of the defendant's obligation. See Chukuma versus Shell Petroleum Development Company. I hold that the failure of the defendant to pay the claimant his salary in lieu of notice at the date of termination of his employment is in breach of the contract of employment, and it is wrongful. The defendant is ordered to pay the claimant the sum of 344,635 naira, being 1 month's salary in lieu of notice. I declare that the defendant's letters dated 14th November 2016 and 15th November 2016, terminating the claimant's employment without any reason or justifiable reason, are wrongful and a breach of the contract of employment. The main head of Claim Relief 1 succeeds. The position of the law is that the wrongful termination of the claimant's employment entitles him to an award of damages. Learned counsel to both parties are in agreement on this position as canvassed in final address. However, the claimant did not make a specific claim for damages. Rather, he has made a claim for arrears of salaries and emoluments under the mistaken belief that his employment was won with statutory flavor. In final address, learned counsel to the claimant has argued in the alternative that he is entitled to be paid his salary and allowances from 31st November 2016 until judgment as damages for wrongful termination. It is the primary duty of this court to do substantial justice. In Oak Pensions Limited versus Olayinka, Garba JCA, as he then was, now JSC, stated succinctly, and I quote, "It should be noted that the primary duty of a court of law is to do justice, at least substantial, in all matters and causes that come before them, for adjudication by a dispassionate appraisal of peculiar facts, evaluation of the material evidence, and application of the relevant laws and rules of equity. In the determination of the justice of a case and the entitlement of the parties in equity, the facts and material evidence placed before a court are sine qua non. The decision to make any order in a case, whether sought for or not by any of the parties, must be predicated on such facts and evidence, taking the rights, obligations, and interests of both parties into account or consideration." End of quote. Having found that the defendant wrongfully terminated the claimant's employment by issuing 2 letters of termination with immediate effect without any reason, he is entitled to an award of damages pursuant to the provisions of Section 19D of the National Industrial Court Act 2006. I hereby award the sum of 8,271,240 naira, being the equivalent of 24 months' salary, as general damages. The defendant is to pay the claimant the sum of 1,750,137 naira 42 kobo, being his terminal benefits, stated in its letter dated 7th November 2016. The claimant is seeking an order that the defendant reimburse him for the cost of traveling flights and shipment of personal effects for the purpose of resuming duties upon appointment by the defendant. The defendant asserts that the passage and baggage allowances presented by the claimant was an outrageous amount, and that the claimant wrongfully added the cost of shipment and clearing of his Mercedes ML Jeep 2003 and one Saab car 2001 with his personal effects, and this made it difficult to ascertain the actual cost involved. There is no dispute that the defendant recruited the claimant from Vancouver, Canada. Clause 13.1 of the Defendant's Staff Handbook and Conditions of Service provides, and I quote, "A member of the senior staff recruited from overseas shall be entitled to economy class air passages or approved first class C passages for himself, his wife, and up to 4 children, and a baggage allowance." The provision specifies the baggage allowance for air travel, sea travel, and also states that a staff can claim under one category only, and that baggage does not include a motor vehicle. The claimant's claim is for both air and sea passage, contrary to the provisions of Clause 13.1. Furthermore, the order of reimbursement sought is in the realm of special damages and must be specially pleaded, particularized, and strictly proved. Luke Onyora versus Benedict Onyora. The claimant failed to plead the specific items for reimbursement or give necessary particulars in the pleadings. This is not the duty of the court. Consequently, this head of claim relief 4 is refused. For the avoidance of doubt, I hereby declare and make the following orders. 1, I declare that the defendant's letters dated 14th November 2016 and 15th November 2016 terminating the claimant's employment without any justifiable reason or any reason are wrongful and are a breach of the contract of employment. 2, the defendant is ordered to pay the claimant the sum of 344,635 naira, being 1 month's salary in lieu of notice. 3, the defendant is ordered to pay the claimant the sum of 8,271,240 naira, being the equivalent of 24 months' salary as general damages. 4, The defendant is to pay the claimant the sum of 1,750,137 naira 42 kobo, being his terminal benefits. 5. Defendant is ordered to pay costs of 300,000 naira to the claimant. 6. All sums are to be paid within 30 days. Thereafter, the sums will attract interest at the rate of 10% per annum until fully paid off. Judgment is entered accordingly.
As the court pleases.
As God pleases.
Thank you. We are most grateful, my Lord, for the well-considered judgment.
My Lord, we are very grateful for the erudite consideration of this particular judgment. My Lord, may I ask, since we are not at the venue of the judgment, how soon and how possible we can assess the judgment, my Lord?
The judgment will be sent to the registrar in Lagos within the next few days. Within 3 or 4 days, the registrar in Lagos will get the soft copy of the judgment. The soft copy of the judgment will not be signed. It will only be the physical copy of the judgment that will be, the hard copy of the judgment that will be signed. But the registrar of the court will forward to your email address a soft copy of the judgment, pending when the hard copy is sent to Lagos, and then you can apply. And then, of course, within the week, the judgment will also be uploaded on the website of the court. So all of this will be done within the next few days. So
okay,
as soon as
in the next 1 week.
As the court pleases.
7 days, all of that will be done.
7 days. We are very grateful, my Lord.
All of that
We are very grateful.
We are very grateful, my Lord.
Registrar, I have 2 other matters. Is it the same? Is it the same details? It's a different one. Okay. Okay. All right. I will.